Kevin Lemley. Welcome to our series on estate planning. What we're going to talk about here is how we're going to take care of your assets, how to take care of your loved ones once you're gone, and answer some of the questions, the differences between power of attorney, a will, a trust, and things like that. So what we're going to start off with is talking about a power of attorney. And so what it is, what we can do with it, what we can't do, and that sort of thing. In Arkansas, there's two different types of a power of attorney. First is a medical power of attorney. This is what someone will have when they'll take to the doctor that says, all right, I have authority to make medical decisions over this person. If you're in the hospital, you're incapacitated, you've been in a wreck, whatever, if you've given this medical power of attorney to somebody, then they can make those decisions and let the medical staff do everything that they need to do to take care of it. You'll also hear this called a living will. We put into ours what are the parameters to keep you on life support or to take you off. So if you hear the term living will, that's kind of used interchangeably with what a medical power of attorney is in Arkansas. In Arkansas, it's a separate, specific statutory language, so you have to have that. Next type of power of attorney is what's called a durable power of attorney or a general durable power of attorney. And this is going to let somebody do everything else for you. They can open and close bank accounts, buy and sell real estate, basically do everything that's not medical. And the way it's structured here in Arkansas, we have a list of all the powers that the person can do, and you can grant them everything or just part of it or whatever is going to suit your needs best. Sometimes it makes sense to give someone a total power of attorney over you, and then sometimes it doesn't. So that's just something that we could go over. Now, when we're dealing with the power of attorney, so let's say I'm going to give power of attorney to my wife. I have to be able to grant it to her. And so this might sound kind of silly, but we get these calls fairly frequently where a loved one has passed away and then the relative is trying to get a power of attorney over them or the estate. It doesn't work that way. So if the person's already passed away, we've missed our opportunity to get the power of attorney. Also, we'll get the situation where the loved one has Alzheimer's or dementia, some sort of mental disease or defect where they can't take care of themselves, and then now the family members coming in and wanting to get power of attorney. Well, we can't do it in that situation either because the person has to be of sound mind to be able to grant the power of attorney. And so if we already know that this person has dementia or Alzheimer's or something like that, we cannot in good faith execute a power of attorney for that. So you just missed the boat there. The power of attorney can be great, but it has the person granting it to you. They obviously have to be alive. They have to be mentally competent. And as long as we have that, it's fairly simple to get it set up. It's just a matter of how much power do they want to grant to you? How much do they want to withhold? And then if we're in the situation where the person is already mentally incapacitated, then we move on to guardianship, which we'll talk about in another video. And then if they've already passed away, then we have to move on to something else, probably a small estate. But that's how our power of attorney works. Thanks for tuning in.